because he thought that that law would be used to serve the enemies that would be perceived. Do you know what, Your Lordship? Ibingira was the first person who was deported under that law to Karamoja region. That draws a lesson, Your Lordship, for us all, that this impeachment is not about His Excellency Rigathi Gachagua. Again, I confirm, it's about the posterity of our nation. Your Lordship, when it was argued that His Excellency has been taken ill, my submission, Your Lordship, is that Article 19, Article 21, Article 20, Article 24, Article 25, Article 27, and Article 28 kicked in. We are no longer now looking at the expediency of the impeachment, but looking at the right of that particular individual, the right to life, right to equal protection before the law, right to the dignity. That is what we were looking at. The Senate ignored all those. But what does Wambora tell you? Wambora case tells you, look and see whether there was a violation of the rights. Your Lordship, our submission is that there was serious transgression of those rights. Your Lordship, permit me to draw your attention to section, as I go to my next point, Article 138 of the Constitution, Clause 2. It speaks about the procedure at the presidential elections. I will draw parallel later. If two or more candidates for the president are nominated, an election shall be held in each constituency. My interest is the word each constituency. When looking at this, Your Lordship, and having submitted earlier that the office of the deputy president are derivative of the office of the president, when the Nation Assembly was called upon to initiate public participation, they were supposed to initiate this public participation in the same manner and the same mode this particular person they're removing from office came into office. You reckon, Your Lordship, that in the case of Maina Kiai, it was decided that the election is at the polling center. That election at the polling center, Your Lordship, is the most minute space where the people can exercise their sovereignty. So if we are putting in a president and the deputy president at the polling station, how do you remove him at the county headquarters? How do you make relevance of the county headquarters being the forum for public participation? How did my mother in Karusho participate in the removal of the deputy president? Yet that removal affects her sovereign will. So, Your Lordship, I will draw you to an affidavit by my friend David Madenge. David Madenge is not just another individual. David Munyi Madenge is a member of the County Assembly of Kirinyaga. He says at paragraph 9, paragraph 11, that he participated in that process. He has even annexed photos in that particular affidavit where individuals were blocked from accessing those so-called public participation forums. This is an elected member. His affidavit must be considered in the weight it deserves, having been a member who is already enjoying the sovereignty of the people. And again, Your Lordship, when you're looking at this affidavit, again look at the annexure marked as PP, as DMM1. This is the National Assembly announcement or notification of the extension of the public participation. They quote and rely on the decision of your brother, Justice Mwongo. Justice Mwongo, and that is the reason why my learned friend, the Member of Parliament for Kirinyaga, Honorable Njeri, referred to the notice of motion that brought forth these particular orders, was specific as to the forums where the public participation was to take place. The judge was therefore reading Article 138, Clause 2, that we must go as close as possible. We must decentralize as much as we can to ensure that there is meaningful, there is quantitative and qualitative public participation. But when you put it in a notice like this, my mother at Karusho, she hardly reads newspapers. She hardly reads newspapers. And Karusho, your lordship, is about 130 kilometers from where we are seated. We also have individuals from where we are seated in Banisa who are 700 kilometers from where we are. A newspaper is published. Tell me how Galo, how Muhammad, how Hassan had the ability to participate in this process. Just become pragmatic, my lords. View it in that lens. Your lordship, as I sum up, permit me again to draw your attention to Article 50. Article 50, Clause 2, Paragraph H. Your lordship, the deputy president was unable to attend to his defense. Most importantly, your lordship, for this court to note, is that the deputy president was the only witness for that case. He was not to call any other witness. And he has been denied an opportunity to defend himself. You will hear my learned friend, Senior Counsel Tom Ojenda, telling you that Article 50, Clause 2, Paragraph H, permits such kind of a conduct. It says, your lordship, every accused person has a right to a fair trial, which includes the right, H, to be present when being tried, unless the conduct of the accused persons makes it impossible for the trial to proceed. I am very sure they would have relied on that, your lordship. Let me preempt them. Your lordship, two things here. In Wambora's case, Wambora indicates, that is Wambora, the locus classicus, that the process of the impeachment is neither criminal nor civil. Therefore, this provision cannot be taken as an exemption to create the necessity for the deputy president to be available during the process of the impeachment, because it's distinguished that this specifically applies to an accused person. And Wambora has said that an impeachment is neither criminal nor civil. So there was no possibility, your lordship, that his presence could have been done away with. It was mandatory, your lordship, for the deputy president to be present during the trial. As I sum up, your lordship, you might then ask yourself, in the circumstances, your lordship, where an individual has not been heard, where a person has pleaded his unavailability as a result of illness, what was available for the Senate to do? I sat through, I was present, Senior Counsel Paul Moite making an application for adjournment up to Tuesday. They rushed as if London was burning to deny that right. What was the reason, your lordship? They said that this was a time-bound process. That's a fallacy. That is a legal fallacy. This was not a time-bound process. And I look at it in two ways. If we were to say, your lordship, that the impeachment was to take place at the committee stage, there were 10 days provided for. If you were to say that the impeachment therefore was to take place as it did in the plenary, there were no rules requiring or giving the time period within which that process must be complete. May I repeat? When they opted for the plenary, and when they failed to modify this process so as to bring into conformity with the circumstances of the case and to create the necessary legal procedures for the impeachment, they went for it in a blanket manner, because the plenary itself did not prescribe the time period within which this impeachment must be completed. Your Lordship, to the extent that this Senate failed to grant the Deputy President an opportunity to defend himself and hid behind the timelines, which are not constitutionally provided for because they went for the plenary, then, Your Lordship, there was a transgression of Article 25, which provides for the non-derogable rights, and a transgression and a violation of Article 50. We cannot look at it in any other way. There were no rules. The Speaker did not guide the members of the Senate as to how the plenary was to proceed if it were to sit as a quasi-judicial process. Lordship, as I invite my learned friend, Mr. Nyamu, permit me, Your Lordship, to urge you to admit these petitions. I equally associate myself with the submissions made in petition by the first petitioner and all the petitioners who have submitted before. But again, look at the affidavit of Honorable Jerry Maina. Again, Honorable Jerry Maina is not any other person. She's an MP, a member of parliament, who sat all through in that parliament, who sat and contributed to that motion. When she tells you that in her constituency there was no public participation, who am I to deny? Who am I not to believe her? She's elected. She has a distinct, identifiable constituency that her affidavit speaks about. Your Lordship, permit me to invite my learned friend, Mr. Nyamu, and urge you, Your Lordship, to find that there was no impeachment at all, and my Lord, to quash the said impeachment. But while quashing it, Your Lordship, again remember that there is nothing unjusticiable before you. The question of justiciability has been dealt with in the case of Wambora 21, and again, the case of unjusticiability, Your Lordship, that constitutional virginity was penetrated when Article 165, Clause 3, Paragraph D was enacted. That this court can penetrate the works of the Senate, the works of the National Assembly, to see to it whether it was done in accordance to the Constitution. It no longer enjoys that constitutional virginity. Mr. Nyamu. Thank you, Lordship.
Thank you.
Thank you, my lords and my lady. Yes. In the interest of justice and time, I do not need 10 minutes. I only need 4.5 minutes. Yes. My lords, my lady, my learned colleague, Gachagua, has submitted exhaustively. So, I will only be enumerating the reliefs sought. My lords and my lady, at the heart of this petition lies the doctrine of popular sovereignty, as codified under Article 1, which vests the sovereignty or the sovereign power in the people of Kenya and permits its exercise either directly or through the democratically elected representatives. My lords and my lady, the office of the Deputy President is not an appointed or technocratic office. It is a direct product of a universal suffrage, deriving its legitimacy from the will of the electorates expressed at the ballot. It therefore follows that any process that seeks to remove a deputy president from office must be approached with heightened constitutional sensitivity and restraint. It implicates not merely the tenure of an individual office holder, but the sovereign will of the people themselves. Therefore, as a result, and culminating from our submissions, we have sought the following reliefs. One, a declaration that the impeachment proceedings against the deputy president were conducted in violation of the Constitution of Kenya and were therefore unconstitutional, null, and void. Number two, a declaration that failure to apply the modification framework under Article 152, read together with Article 144 and 145, as required, rendered the entire impeachment process fatally defective. C, a declaration that the proceedings violated the petitioner's right under Article 52A, as well as 26, 28, 48 of the Constitution. D, a declaration that the Senate acted in breach of its own standing orders, including standing orders number 75, 78, and 80, thereby rendering the proceedings procedurally ultra vires. E, an order of certiorari quashing the impeachment decision and all consequential actions arising therefrom. F, an order of prohibition restraining the implementation, enforcement, or further reliance upon the impugned impeachment decision. And lastly, any other consequential or auxiliary order that this honorable court may deem fit and just to grant. Thank you very much, my lords and my lady.
Thank you.
Your Honor, I had asked for 15 minutes. I'll try to maintain that. I acknowledge that I see I'm the last petitioner. It's based on, I believe the petitioners are really exhausted and have given admirable, so their submissions with admirable force and clarity that I feel like I'll only be doing closing remarks because they have almost said everything.
Please tell us your name.
I'm Momanyi for the 58th petition.
15th.
58th petition.
Yes.
Yeah, 58th.
They are not here.
Yes, Your Honor. Your Honor, we do rely on our petition, which is dated the 18th of October 2024 and amended on the 23rd of October 2024. Our submissions are also dated, our submissions and list of authorities, dated the 2nd of January 2026. Your Honor, I'll seek not to traverse grounds that have already been submitted upon by my fellow petitioners. I'll only seek to maybe highlight or underscore cardinal aspects that I think maybe have not been mentioned or have not been given in the flavor that the petitioner herein may have wanted to do. Your Honor, we do submit that, looking even at our submissions, we submit that this impeachment does rest on one singular but profound constitutional question. And simply, this question, which relates to the issues that we've put before this court, is whether the impeachment of the deputy president, the former deputy president Rigathi Gachagua, His Excellency Rigathi Gachagua, was conducted in accordance with the Constitution, or whether it represent, or whether that impeachment process only represents what we term as a fundamental misapplication of constitutional power. In our submissions, we submit that the impeachment process in its entirety is a definite misapplication on constitutional power. And when we speak to constitutional power, we do rest our arguments on Chapter 1 of the Constitution of Kenya. Article 1.1 of the Constitution of Kenya does state that sovereign power belongs to the people of Kenya and shall be exercised only in accordance with that Constitution. And when you read that provision, Article 1.1, we are reading it together with Article 1.3, which provides on how this sovereign is to be exercised through delegated power. And this delegated power has been delegated to the three arms of government. And in our submissions is that the parliament violated this power that has been given by the people. And we say that when delegated power, which the parliament wielded so capriciously for political convenience against the very people from whom that power was given, that exercise ceased to be constitutional governance and only descended to be constitutional betrayal. And you see a parliament that indeed betrayed the sovereign power that has been given by the people and conducted an impeachment process that is not only unfair, but also an impeachment process that gravely violates very many provisions of the Constitution. In our petition, we quoted 20 provisions of that Constitution. The petitioners that have come before me have listed a lot of those provisions. I wish not to repeat. But only in summarizing my arguments under Article 1.1, I seek to remind this court of the quote by Justice Emeritus Chief Justice Maraga, when he said that the greatness of any nation lies in its fidelity to the Constitution and adherence to the rule of law, and above all, respect to God. And we also submit that the only way to preserve the rule of law is to apply it equally to everyone. And many petitioners who have come before me, they have said that the impeachment process fell well below the standard of the Constitution. Your Honor, this impeachment process, as it is, opens a constitutional backdoor to power. It provides an alternative way in which the direct vote of the people has an alternative whereby we can easily impeach a leader who has been validly elected by the people through such of a sham of an impeachment process. And we urge this court to shut this door, because this impeachment, the way it was done, it puts the country at a very bad position. And as it has only left a constitutional backdoor to power, which we submit should not be allowed, as it will be an alternative pathway to electoral that determined as predetermined trials with unfair outcome. I do not know the two, but I know at least the trial of Jesus Christ. And I say in my humble submission that at least with the trial of Jesus Christ, Jesus was given the opportunity to be heard. In this impeachment process, it really, when you look at it, and you look in a constitutional democracy of the 21st century, such as Kenya, with a constitution that is celebrated across the globe, with a constitution that has fidelity to human rights and due process, you can really make a conclusion that this parliament sank very low. Even when you look even at the conduct of the speakers of both parliament, and I also relate it to the trial of Jesus, I say that at least the Pontius Pilate washed his hands when he saw that people could not move. But when you look at the Senate, instead of calling the House to order, they prevailed even to vote. Like the Speaker of the Senate went ahead to put put a vote on whether someone's constitutional rights of a fair hearing should be respected. Your Honor, Article 50 contains rights that are not only inalienable, but also non-derogable. And that was a great violation of the Constitution. Your Honor, I seek to move to Article 145 and 150. And the petitioners who have come before me have made arguments both on the threshold and the process. And they have submitted that this process failed in both, not only in process, but also in threshold that is required by the Constitution. When you look at process, and I submit on Article 145(3), they made very many distinct legal arguments on whether it is a discretion or the Constitution requires that there must be a special committee. Your Honor, I'll only argue on English, plain English, even literal rule in interpretation of that provision. Your Honor, when you use the word may and you add and, you remove it as an option. When you say, for instance, I want to see, may I see John and James? It is either you see John and James or you don't. And I submit that that may that has been put there is only functions whereby the Senate may not proceed to impeachment. There may even be a preliminary objection, notice of objection on the floor of Parliament, maybe something that has emanated from the National Assembly that prevents even the Senate itself from proceeding to impeachment. But we submit that as per Article 145 and 150, there must be a special committee for investigations. On the aspect of threshold, the Constitution is very clear. It uses the word serious, it uses the word gross. Your Honor, these words are not ornamental. They have a purpose. The framers of the Constitution put them there for a particular purpose. And by use of those terms, it means that there are offenses that are impeachable, and there are also other offenses that are not impeachable. And as such, we submit that none of those charges met the threshold. And I'd like to maybe dwell on the common ground, the issue of shareholder. When you look at the mover of that motion, there's nothing he presented apart from the argument that when the deputy president was talking about shareholder, those words were divisive, those words were inciting the public. No other evidence was brought in Parliament. Your Honor, what this mover wanted is that he put himself out as an authority to tell the Parliament, both houses of Parliament, that the term shareholder is inciting, the term shareholder is divisive, the term shareholder is against the National Cohesion and Integration Act, without even the institutional backing of that body, which enjoys public money, taxpayers' money, for it to act. Even the Senate did not proceed to conduct investigation so that they can establish these words divisive, as the National Cohesion and Integration Commission deemed it as insightful and divisive. We submit that it lacked authoritative and institutional support. So it was just the words of the mover of impeachment. I believe we dwell on the Latin phrase of ipsi dixit, which simply refers to somebody, a speaker, simply telling people that, believe me, I'm the authority. This is what I mean when I say that these words are divisive and insightful. On Article 152.
Council, you're in your last 2 minutes?
Yes, I'm finalizing. Yes, a minute.
Minute and a half.
Yes, Your Honor. Yes, my lady. Your Honor, as I finish on Article 152, the petitioners who have come before me have made valid arguments on that provision. I seek not to go deep into the legal aspects of it. I only seek to direct this, my lords and my lady, to the Senate Hansard on the 17th of October 2024. I see Mr. Ojenda has been, Professor Ojenda has been attacking petitioners for mentioning Sifuna. Let me make a change and mention Okia Omtata. And Mr. Okia Omtata, these words, even if these words are adequate to prove that this provision was violated. He says that I stand here to look at whether the House has complied with the Constitution, and he mentions Article 152 on removal of the Deputy President from office. And he makes similar submissions to what my senior, Mr. Ndegwa, has made, that the role of a Deputy President is derivative. So when you move to impeach a Deputy President, you must acknowledge that aspect. And he says that these modifications have been couched as a mandatory. So when you're making impeachment of a Deputy President, you must do the necessary modifications. Your Honor, I will not proceed to, I will rest at this position. My prayers are similar to what other petitioners have prayed for because of time. I'll not proceed to mention and rest my submissions at this position. Thank you very much.
Thank you very much. We have come to... Who are you? Oh? How much time do you want? Okay.
So I will use 5 minutes and allow my colleague to use 5 minutes.
All right.
5 minutes, it's now 2:30, so 2:35.
Just before I start, I just wanted to mention that we have filed our trial bundle dated 15th of April on behalf of Kitusa Sheria, and also our submissions unserved.
Your name again?
My name is Mosongo Maosa. I appear alongside Margaret Awor. May I start? Okay. Your Lordships and your Ladyship, our Constitution contains very many promises. I will just highlight 5 promises. One of it is the promise of constitutional supremacy, that Kenyans, in exercise of their sovereign power, determined in Article 1 and 2 that sovereign power will only be exercised in accordance with the Constitution. And secondly, that the Constitution will remain supreme and at all times be followed by all organs. They were not fake promises, and Kenyans made these promises because they intended to keep every part of it. What you're arguing is that in this process, the respondents did not honor this promise that the Constitution is supreme and must be followed. Secondly, we want to argue that there was a promise that through all processes of governance, there will be transparency and public involvement. In Article 10 and 118, Kenyans had the good intentions to ensure that the promise that in all processes, the public participation of the people will be inculcated. That promise, they intended to keep it. And we are arguing that the respondents did not safeguard this promise. The third is that there is a promise of fair trial and administrative actions. a promise means everything, and once it is broken, sorry means nothing. The first petitioner had been promised by Kenyans that he will be entitled to a fair trial and a fair administrative action. Your Lordship and your Ladyship, broken promises are the reason why some people are scared to trust again, and that's why if I've asked for 5 minutes and I take more 1 minute, you wouldn't trust me again. So the same way, if Kenyans had indicated that the first petitioner would have the right to ask for an adjournment, to be present and appear, and be able to defend his case, and that right is taken away, it is unfair, and some promises can break your heart too. And in this case, he actually ended up in hospital. That this promise that had been, that he will be entitled to public participation before his removal was not safeguarded, that the processes relating to his removal would be fair, and it was not fair, he ended up sick. And we are saying that in the same manner, we urge this court to safeguard this promise of a fair trial and administrative action. I still have 1.5 minutes. The fourth promise is that our Constitution, in Article 104, 145, 150, 152, 168, gives the promise of fair removal for state officers. It's not only the Deputy President who is required to be removed in a fair process, but also members of Parliament in Article 104, there's a right to recall. Our learned senior Professor Tomogenda, if the people of Kisumu so wish to recall him, they can recall him, but the Constitution requires that that process must be fair. Even the current president, His Excellency William Ruto, if he has to be removed, the process must be fair. And because we are now setting precedent on how they will be removed, we urge this court that the process and the promise that was given to the Deputy President was not safeguarded. There is no greater fraud than a promise not kept. We urge this court that, as Article 165 states that this honorable court has the power to intervene, and now that my 5 minutes are over, we urge your lordships and your ladyship that this promise of judicial protection of this process be safeguarded, that in as much as Parliament did not keep their promise, that this process ultimately, the judicial scrutiny, will also be kept. Thank you. I allow Margaret to do the remaining 5 minutes. Thank you, your lordships.
Thank you for keeping your promise.
Thank you, my lordships and my lady. Much has been said about public participation, but what I'll hammer home is the public participation that was conducted by the respondents. The National Assembly did not meet the thresholds of Article 10 and Article 118 of the Constitution of Kenya 2010. The Constitution of Kenya, Article 10 and 118 of the Constitution of Kenya provides that the public participation that should be accorded is one that is reasonable and one that is meaningful. The one that was provided by the National Assembly did not meet these thresholds. Why do I say so? If you look at the public participation that was conducted, it was condensed to 47 hubs, which was conducted in a hurry. Let's take Nakuru SK Showground. It encompassed people, citizens from Molo, Njoro, Naivasha, Gilgil, Kuresoi South, Kuresoi North, Subukia, Rongai, Bahati, Nakuru, Nakuru Town West, and Nakuru Town East. My lords, my lady, this required citizens to travel from far places to one single center that what they were going to do was to vote, a chat box voting, not an engagement. That did not meet the thresholds of Article 10 and what Article 118. Your Honor, sorry, my lords, my lady, you have the mandate or the power to intervene when procedure is not followed, when the procedure that is provided for under the Constitution is not followed. This power is provided for under Article 165(3) of the Constitution, and also as it was hammered in the Wambora case, the Court of Appeal, that you may only come into where necessary to confirm that the process has been properly followed as laid down in the Constitution. We are not inviting this court to intervene or to rewrite politics, but to enforce and preserve the Constitution of Kenya and the rule of law. Our prayers are provided for under paragraph 27 of our replying affidavit. These are our prayers. A declaration that the public participation undertaken by the first and the second respondent in the impeachment process of the first petitioner was neither quantitative nor qualitative as required by the Constitution. A declaration that the notice for public participation issued by the first and the second respondents were inadequate, the time frame provided for was insufficient, and the participatory mechanisms utilized were limited. To declare that the impeachment process failed to meet the constitutional threshold of public participation and is therefore constitutionally defective. Declare that the impeachment proceedings conducted on the 16th day of October 2024 by the third and the fourth respondent were procedurally unfair, unconstitutional, and ultra-vires. Declare that the third and the fourth respondents, acting quasi-judicial, violated Article 47 and 50 of the Constitution of Kenya 2010 by denying cross-examination, re-examination, and a reasonable adjournment. A word, of course, to the seventh interested party, who is Kituo cha Sheria. I humbly submit.
What is the date of your affidavit and who has deponed to it?
15th April 2026 by Professor Wambua Kituku.
Professor?
Wambua Kituku.
Thank you very much.
Thank you.
I believe that is the close of the petitioner's submissions. Is there any person representing a petitioner who has not been reached or interested party? We'll break for 40 minutes to come back at 3:20 to commence the respondent's case. 3:20.
I am so hungry. Wanaacha mtu hapa.
public participation is today you have 1 day notice. No, this time around you have 0 day notice. Public participation is today. 2 days was already bad enough. 1 day was terrible. 0 day notice was horrible. In regard, my lords, to the orders issued by Justice Mongo for public participation as a second stage. My lords, the orders of the learned judge were very clear. He stated that he would allow public participation to continue on 4th of October as the first stage, a stage. And he mandated, ordered, that there shall be a second stage of public participation created as a new public participation exercise in keeping with all the components in BAT. Proper notice, not the 2-day notice. Proper information, not the lack of information provided in the Gazette notices. Proper structures, proper access, and most importantly, as a base, proper sensitization. What happened instead, my lords and my lady? On 4th at 10:22 p.m. and at 10:44 p.m., the clerk of the National Assembly drafted a press release, and that same press release was published in the, I think it was in the Nation and the Standard. That press release, my lords and my lady, was for extension, my lord, of the first stage, not a new stage. If you look at the affidavit of Jen Jeremiah, that would be in JNM2. If I can find it, 1 second. This advertisement is on page 14 of the annexures to JNM2. It reads, notification of extension of public participation. My lord, purportedly in compliance with the orders of the Honorable Justice Mwongo, the clerk of the National Assembly decided, no, we will not do a repeat exercise. We will simply add 1 day to the exercise that is already ongoing, which the Honorable Court already has issues with and has issued directions in regard to, and instead we will just extend it. And what does this Gazette, this advertisement do, my lords? It does not, this time round, even bother to provide the grounds in which the motion seeks. It does not bother to include pullouts. It does not bother to make any attempt to provide any information, and simply makes the assumption that anybody that this advertisement is directed at will know what to do. It does not provide any venues and simply states there will be public participation at the constituency level. In the first, second, and third advertisements, there were 47 venues for the counties, specific venues. For example, Tononoka Social Hall, for Mombasa. Kwale Cultural Center. They were very specific. But for the 290 constituencies, absolutely nothing. My lords, to compound the problem, the clerk and the National Assembly were clear in their minds that what would be required by the public in regard to sensitization and information should be provided. So what do they do? At the bottom of the advertisement, they provide a link to what they call the template. It is a link, and this is to the template. But at the bottom, in regard to the notice of motion, any evidence, and all the documents that they rely on, they provide at paragraph 5 of that advertisement that copies, and I'll read verbatim, copies of the special motion stating the grounds for removal and particulars of the allegations, together with the relevant documents, may be downloaded from the Parliament website. That is all. Telling Kenyans that you are invited to participate in this impeachment process, the evidence that you need to look at, the grounds that you need to look at, all the information that you require is on some website. We know that you will need this information, but you go look for it yourselves. It does not say that we will provide the information for you at the venues, and no proof has been filed in court to show that at any of the venues where public participation took place were the notice of motion and all documents pertaining and all particulars ever provided at the venues. That, my lord, is the failure of the Gazette notice itself. Then, my lords, if we look at the pullouts, what has been termed as the template, you will find one of the pullouts, if you look at, if we look at page 235 of the annexures filed on behalf of the 2nd and 7th respondents, again in the affidavit of Mr. Njoroge. I will be speaking to the affidavits in these, the annexures in this particular affidavit. My lord, if you look at this template, what is being called a template? It is purportedly a template to collect views. A template to collect views. My lords, from our understanding of what a template is supposed to be, is that somebody will take a template and then convert it for specific use. This is no template. My lords, if you look at it, it is nothing but a ballot paper. This ballot paper, being called a template, asks the people who will use it to make an election on a specific motion and on specific grounds, 11 of them. Paragraph 6 of this ballot, my lords, asks, what are your views on the motion? And tick, what is your vote? It is not a view. Do you support? Do you not support? And other, specify. This is a ballot question. It is not a view. Each of the 7 grounds provided from paragraph number 7 does exactly the same thing for each of the grounds. For the grounds themselves, no information is provided that could help my grandmother in Kimoro village, Nandi County, to understand what gross violation of Article 10(2)(a) is. It is an absolute impossibility. If she was to make that tick, it would not be based on any information. Why? She was never sensitized. She would not understand what she is taking in this ballot. And we will keep insisting that it is a ballot. My lords and my lady, and it is important that we note, at the end of this ballot paper is a date, and that date is important because there was a purported public participation exercise on 4th of October and another on the 5th of October. So we assume that for every form that was returned, it was signed and there was a date. There was a batch for 4th of October and there was a separate batch for 8th of October. And this will become important when we move to the report from Parliament on public participation. My Lord, I would like to make a note on the public announcement on 2nd made by Parliament on their social media. You will find it at page 239 and 240 of the annexures of Mr. Njoroge. And it shows that on page 239 that what they called as notification to the public received 125 comments, 19 shares, 203 likes. The penetration was close to 0. On page 240, I guess they decided to clip that out. Did not want to show it. So then, my lords, we've walked through the process itself on public notice and the template, the ballot paper that was used to gather views. So then, my lords, we move to the report itself. This report is a report that is supposed to show that indeed there was public participation that occurred. The bulk of the report that has been filed in court is pictures from 290 counties. And those pictures, I think, begin from page 296 of the affidavits that I refer to, Njoroge, and starts with the pictures and information from Ainapkwe constituency. And this, my lords, is where it becomes clear on what this exercise really was. For Ainapkwe constituency, at paragraph 61 of this report, it states that the public participation exercise took place at Ainapkwe NGCDP office. A total of 959 members of the public took part in the exercise. Of this, 808 persons indicated that they supported the motion, while 133 persons did not support the motion. Further, 18 persons expressed other views with regard to the special motion. Obviously, my lords and my lady, I did not belabor the point, but 808 persons indicating that they support is a vote. It is not a submission. But what is more telling is that the public participation exercise took place at Ainab Koi NG CDP office. You were not told when this happened. Was it on 4th? Because if it was on 4th, there was definitely no public participation at Ainab Koi. Was it on 5th? There is a possibility it would have been on 5th. But we are not told. From the report that you will see at table 2, actually table 3 of the National Assembly data, that table starts from page 436 of the annexures, which is a combined tally of all constituencies. You hear absolutely nothing about views collected at KICC, views collected at Bomas of Kenya, views collected in any of the 47 venues. All you will read is from number 1, Ainab Koi constituency, 970. Ainamoi, 756. On and on until the very last one, with the total being shown here, being 224,877 votes. None of them tell you when these views were collected. And this is the only evidence placed before you to show that public participation took place. A table that is unverifiable. A table that is unreliable. And my lords, this unreliability is deeper than just these numbers shown on this table. There were 11 grounds. You have not been told or shown how many people supported ground 1. Gross violation of Article 10, 2A, B. Of the people that supported the motion, if they actually understood what they were doing, how many people supported ground 1? That information is not provided. We say because the information is not available. If it was, it would be before you. How many people supported ground 2 on Article 147? How many people supported any of the 11 grounds? My lords, you're not told this. Yet this is supposed to be the result of public participation in an impeachment process, and all you have received is ballot numbers. A count. No views at all. You are not told that in Ainab Koi we had discussion and were submissions, and 1 or 2 people, or none, stood up and said something. Absolutely nothing. My lords, those pictures that you will see show absolutely nothing but an election in makeshift ballot offices. My lord, if you look at page of the report again, going back to the report, And this should, page 286 of the report. Consider this statement made. At paragraph 58, page 286. It reads, and I need to repeat this, read this verbatim. At the close of the period for public participation as extended, a total of 38,065 submissions were received. And at A, via email, 7,106 submissions were made. Hand-delivered, 30,955. My lords, public participation ended approximately, let's say, 5 p.m. on 4th. Same time on 5th. Somehow, my lords and my lady, and this should make it clear that the information being provided to you is garbage. 30,000 Kenyans somehow walked into the National Assembly to deliver submissions to the clerk. My lords, even if each of these 30,000 Kenyans took 1 minute, just 1 minute, that would be 30,000 minutes. That is how long it would take. 30,000 minutes. Even with multiple clerks handling, it would be a total of 7 days to process that kind of bulk input. The only inference that can be drawn from these numbers, 30,955, it is fiction. As the rest of the tables are absolute fiction. My lords, from those numbers, from that information, it is clear that all we had was a count, a ballot, and unverifiable at that. So what is supposed to have happened with this information, if indeed it was public participation and should have been considered by the National Assembly? I will direct you, my lords, to the Hansard, which is from page 1078. That's the Hansard starting in the morning at 9:15 a.m. for the morning session, and from page 1137 to starting at 2:30 p.m. My lords, I've made a summary because this is approximately 160 pages, and I'm sure you will not want me to walk through each of those pages. So instead, this summary, or rather the Hansard, provides the proof that even if something happened out there, the purpose of public participation should be that Parliament will consider the views of the public. Even if they disagree in the end, they must be considered. What did Parliament do? What actually happened in Parliament? My lords and my lady, at about 9:30 a.m. on 8th of October, the Honorable Millie Odhiambo tabled the report, the public participation report. This is the first time it has moved from committee, coming to Parliament for consumption. It is tabled at 9:30. my lords and my lady, what happens immediately after that? The motion is moved, and away we go. The report has not been considered. Debate, the motion is moved, debate starts immediately. The Honorable Odhiambo is advised that she would have 15 minutes sometime during the day to speak to the report of the Committee on Public Participation. By the time she tables, by the time she gets to speak to that report, 21 members of parliament have already spoken without having had anything. In the afternoon, all the other members of parliament, the honorable members, participate, and in total, the participation from them is 66 members speak, either in support or in opposition. And as you can see, the petitioner is at number 58 of that graph, and she opposes. But the damning evidence from this summary, and the whole answered, my lord and my lady, is that of all 66 members that participate, all 66, only nine members mention public participation or the views from their constituents. A whole day. Not any mention of the views from Mombasa County, from Kakamega County. Nothing. And the reason being, and it is rather obvious, that report sat on the table of Parliament with nobody touching it. Nobody looked at it. Nobody knew what its contents were. They had absolutely no opportunity to participate with it. My lords, I would like to leave it there. But in the end, if there ever was this exercise is a dead ringer for the concept of GIGO, garbage in, garbage out. My colleague, Mr. Nderitu, will handle the prayers. And as I said before, I donate my 30 minutes to Mr. Kibi.
We took 40 minutes. How much time will you take?
Just 2 minutes, my lord.
2?
Yes.
Oh, proceed.
Or even less. My lords, my lady, my name is Benan Nderitu. I shall be submitting on the reliefs sought on behalf of the third petitioner. Relief number 1. Your lordships, we are seeking a declaration from this court that the impeachment process conducted under Standing Order 64-2 violated the Articles 118, 145, 47, 50, and 10 of the Constitution. Relief number 2. Your lordships, we are seeking a declaration from the court that the modalities placed by the first respondent in respect to the public participation forums of 4th October 2024 fell below the threshold of proper, effective, and meaningful public participation as envisioned under Article 10 of the Constitution. 3, we are seeking that the modalities placed in regards to the public participation held on 4th and 5th October were in disregard of the court order
issued in Kirogoya in petition E014 or 2024. 4, we are seeking a declaration that the public participation held on 4th and 5th October 2024 did not meet the constitutional standards under Article 118 of the Constitution. 5, we are seeking a declaration that the Senate violated Article 118 of the Constitution by failing to conduct public participation. 6, we are seeking a declaration that the impeachment process undertaken by the first and third respondent in view of the public participations held on 4th and 5th October fell below the threshold and therefore unconstitutional.